Now, we've talked about the PIA being 5 years old now. Now, for many, the PIA is different things. For some, it's a fiscal reform. For others, it's institutional restructuring. While for another few, which another law we will be discussing today, it's a community development framework. My panelists here will be discussing some of the key issues which have pretty much plagued the passage of the PIA and the provisions of Chapter 3 relating to the creation of a host community development fund. I'm joined here by my esteemed colleagues and panelists, and I'm going to start by asking one of the key questions that continues to arise. But now there's a very keenly contested point within the Act, which is the sabotage forfeiture clause. And Humphrey, I'm going to ask you a question on that. Now, this is very contested because what the Act says is that if vandalism, sabotage, or civil unrest attributable to a host community results in damage to petroleum facilities or disruption of production, that community may forfeit its host community development trust fund entitlements, equivalent to the cost of repair or damage cost. Now, the problem here from a legal perspective is how do you come about a blanket punishment without fair hearing? There's a fair hearing issue in this. Now, there was a case that got to the Federal High Court where a civil society group challenged this same provision to say, we are going to punish us. How do you even determine the cause of the sabotage, who is responsible, and how do you even make it the responsibility of the community to suffer for this? Now, my question is, following that decision and, with regards to fair hearing, what's a practical obligation that General Counsel needs to take cognizance of in advising clients on documenting incidents with regards to this sabotage and, how the evidential burden will sway? What do you think that General Counsel needs to take cognizance of so that you are able to prove or disprove such sabotage?
Okay, yeah. Thank you for that question. And before I even address it, I would want to also thank the Commission, or the authority, for inviting us to this panel, particularly myself, my organization. I work with Oilserv. We are one of the foremost EPC contractor in the country and also beyond. And sometimes when these conversations happen, we are left out in the room because meanwhile we have a critical stake because in the service delivery curve. So to address your question first, before I will also pivot to a conversation that happened yesterday. What is paramount or key with this sabotage forfeiture clause is for us to understand that the underlying philosophy for the HCDT is about building a co-creation or This one? Okay. It's about building a co-responsibility relationship between the community and the operator. So it's important to bear in mind that's the underlying philosophy driving the HCDT, right? Because the precursor with the GMOs and all of that started that journey. So the whole essence is to tie responsibility so that the community also have some level of ownership with activities in their locality. So placing that responsibility on them certainly is not, I wouldn't want to, for us to go technical about is there a room for fair hearing or not fair hearing, but it's for us to keep tab with the whole essence of this whole setup, because it's about building governance, a framework around that relationship. So from a practical standpoint, what is critical or key is setting a very strict governance framework around that setup. in terms of making sure that the organization, the governance are properly set up of HCDT. And with that in place, it engenders the kind of relationship that needs to support such facilities not to be victims of this sort of sabotage issues. I think we have also seen the results if you follow some of those NMPC reports, when they issue report on instances of vandalism. They have also premised the fact that there has been a substantial decrease by virtue of the fact that some level of strategic relationship has been built between the organization or the operator and the community to have a co-responsibility over facilities within their domain. So, from a practical standpoint, one, I don't consider I sort of appreciate the thinking of or the ruling of the judge in that matter by obviously dismissing that the way which he did, because this is also to save the whole essence of the HCDT, because if that fabric is removed, that could obviously impact on the success stories that we've listened to the state director talk about the journey with the HCT. And to build on that, it's important that the philosophy that underlines it is sustained and kept by virtue of even the courts supporting that spirit, so that we don't lose those gains by trying to erode the level of trust and relationship this framework is set up to do. So what is key, from a practical standpoint, is about having a governance set up around that and have it properly organized and run in accordance with the fact that there is, basically processes to enable that relationship to exist, communications and correspondences. So even if there are grievances, that governance will also have a grievance resolution mechanism well institutionalized in the process to manage this issue. So with that whole philosophy that is driving the HCT is retained and sustained, so that we can also gain the value and the benefit of what it's meant for.
Thank you very much. That's very clear. And you've talked a lot about governance, and it gives the picture that the responsibility is not just that of the operator or the settler, but also that of the community. And that takes me to my next question. The rights versus the limitations. What specific due diligence items should General Counsel insist on in midstream mergers and acquisition transactions? And how should successor liabilities for outstanding trust contributions be structured in these sale and purchase agreements?
Okay, thank you for that. Even before I would deal with it, and also because of time as well, there is one issue I wanted to talk about because it came up strongly yesterday. Yeah. I think that came from Frank. And I think it was a question that was posed to the panel yesterday, but they were not really the panel for the HCDT, but it came up, where the particular reference to him, he was asking that the multiplicity of host community type, there is NCDPRA regulation on host community, as well as the same that you see in the HCDT under the authority regulations. And if the communities are not being shortchanged in terms of the fact that there are multiplicity, and which could also lead to some level of erosion. Yeah. But there's also a missing link as well, which my appeal to the authority would be to also have a look at this as well, so that because the gains or the objective or the philosophy around having HCDT harmonized under a regulation, first under the PIA, giving life to it, and then the regulations to then give effect to the implementation, is to sort of bring some level of governance around host community, which is a critical stakeholder for any the oil and gas value chain. But but the focus has always been on the licensee. So essentially, the oversight has been placed on licensee. So in the case of the operator, and you're looking at when the project has gone live. But in that ecosystem as well, there are also critical stakeholders who have critical role to play prior to for a project going live. So for example, Using my division as an example, Oilserv, for example, Oilserv has been involved in about 80-90% of the gas infrastructure in Nigeria in the past 30 years. They're involved in the AKK, the OB3, and the like. Now, as an APC contractor, you're not a licensee, right? So, but at project inception, you are building a pipeline, for example. You are interfacing with a lot of communities. Now, that ecosystem is not within the framework of the HCDT, but that has a critical impact on project delivery, project cost, because of the interfaces they're going to engage. For example, on the AKK section that we're working with, is a 300-kilometer stretch, cutting across Kogi State, Abuja, Niger State, over 100 communities. But at that space is essentially because the HCT kicks in when there's a project. When this project has gone live, then there's obligation to set up the HCT and the governance around it. But prior to that, there's also the NCD, there's also this host committee push and shove, which HCT is trying to solve. What has been in that space has been what we call some kind of FTO setup, which it is an uncharted territory. There's no governance. So what we try to say is that since we're not involved in this kind of conversations, a missing piece in the ecosystem is the service delivery angle that should come within the ambit of regulation oversight, so that governance is across board. And then that setup up. So I believe if we are to talk about improvement to the regulation, I think that's an area some attention should be paid to. And these are what I feel should be some kind of takeaway from this session as a way of how do we bring governance and sort of structure to ensure that what is perceived to be the key objective of having a host community development trust is also enshrined, and because the precursor is the GMOU, but that is what, because of the uncharted around the GMOU setup, that's why I have this. But in this other service delivery side, you have FTOs all over the place, no clarity. It only depends on to what extent of hand twisting it can push. So if we bring a regulatory oversight as well and some level of governance, then it presents some kind of structure and organization to also enable projects to be delivered within cost and on time. And then the true gains that we expect from this sort of structure is also cascaded down. So that would be my take to the authority as an area of engagement.
Thank you. Thank you very much for that. That was very insightful, because now we know where the pain points, where it pinches. And that's why, Oilserv is very important on this panel. I've always thought about the AKK pipeline that cuts across states. And in determining what host communities you will deal with, if we go strictly by the definition of host communities in the Act, then you have host communities, so many of them. And then we have to determine how are you going to contribute your 3% to all these communities you cut across? But then it's time to throw the questions to the House. Over the 2-day period, there have been questions about host communities. So we would like to, oh, wow, this is encouraging. I see hands springing up quickly. So please, when you ask your question, you please identify the member of the panel you want to address your question. Or anybody can take it if you don't have any specific choice. Thank you.
Good afternoon, everybody. Franklin Ofua. I work for a law firm called Legal Works Associates, and I'm here at the behest of PNG Gas. I have done exhaustive work on host communities, and so with specific response to the issue of control by, I don't like the word settlor to allied companies over HCDTs. The way this works is that the HCDTs are controlled by two separate laws. The Corporate Affairs Commission has a big hand in this, aside the authority. If you go to the extant provisions of the PIA, it says before the companies appoint the board of trustees, there must be a community engagement forum from where the trustees are nominated. The company is only a rubber stamp. Without those nominations coming from the Okpalokus and the Azes, all you're doing is an absolute waste of time. The governance structure is so strong that the company has no hold on any of those things. There's a management committee that is broken into two arms, the executive and the non-executive. And those are controlled by the communities. Then there's an omnibus body called the advisory committee that is a nominee of the host communities that form that trust. The only way companies can control trust is through the nomination or the appointment of the secretary of the board of trustees, which is their sole prerogative, and the management of the fund matrix. There are separate accounts that will be opened on the fund matrix, and some of those accounts has the companies as signatories to those accounts. Finally, just to round up, the companies, I disagree again, do not have an overarching control over host communities. It's actually the committees themselves that control the board of trustees. Thank you very much.
Thank you very much, sir. That's shed light to a pressing issue, and that's very helpful because the communities actually would rather have more control over how these funds are administered. So can we get the next question? Well, there are several questions. Compare, how much time do we have? Okay. So can we have questions, like, let's keep it short so that we could attend to all other questionnaires.
Yeah, so my own is also some form of clarification. My name is Innocent.
Okay.
So also the panel members made mention of the funding of the HCDT and said that the law also provides, except for the 3% OPEX, the law also mandates contributions, gifts, and the rest. My clarification is to the extent that the only part of those funding that is regulated is the 3% OPEX. Every other thing the law provides is not mandated, because gifts, honorarium, and the rest of it, you can't mandate anybody to give you that. It's only the settlor that are mandated to pay the 3% OPEX, and if you don't pay it, there are penalties attached to it.
Yeah.
So looking at the way the HCDT is structured currently in Nigeria, the only funding available is 3% OPEX. I just thought I should provide that clarity. Thank you.
Thank you very much. Thank you. But the point was actually clear. Contributions are voluntary. It's ex gracias.
My name is Bobby Bublem from PNG Gas Limited. My question is regarding the 3% annual expenditure that was copied from upstream and now transferred to midstream companies. For a gas stripping company, a gas processing company, is the cost of gas included in this 3%? Because if the cost of gas is included, then the business may not be sustainable. So I'm pleading for the authority to review the 3% so that it will be sustainable for businesses to operate.
So it's a question and a plea.
And very encouraged by the responses. We expected this because we are all host communities, if you look at it very well. Everybody, it's a pain point that touches you one way or the other. So we're going to take the questions one after the other. There are more questions for Dr. Lamode, but there is one that Humphrey, I want you to answer. There's one I directed to you to please just respond to that, then I will direct the ones to Dr. Lamode.
That's a question with for the lady over there about balance, right?
Yes.
About balance between
balance.
the host community and the critical and the settler, the company. How I want to address this is that the whole it is not talking about balance, it's not a confrontational objective. They're not anti to each other. Rather, I think the balance is anchored on the principle or the philosophy that is underlying the setup, is to create that harmonious relationship whereby both are partners, co-partners on those participating within the locality. So from that angle, it is about a relationship. So that balance exists. So as long as you see it from there, but I saw from some of the comments that was also coming around, it looks as if maybe the issue of control, for example, now looks as if control is more about driving an agenda. But I would say that if we still stick to the philosophy that drives this, then control issues or not shouldn't be, but rather it's about having great company and the community.
Thank you very much. And I like that point, because if we look at where we're coming from with regards to host communities, vandalism, and militant struggle, you see why this Host Community Development Fund initiative being a law is important. Previously, it was like a corporate social responsibility. You either do scholarship for us or you build borehole for us. But now it's an obligation which is punishable if you fail to obey.
Which is why the whole ecosystem was put in that governance framework,
Yes.
so that the gains cascade across board.
Awesome.